Well, good morning, everyone. We've got some more folks jumping on, but we're going to get started. I'm Jane Selta. I'm the Vice President of the Southern New Jersey Development Council. Nearly all of you who are joining us this morning are members of the Development Council. For those of you who are new to us, we're a nonprofit business association whose mission is to promote economic growth in South Jersey through our efforts in hands-on economic development and advocacy. We also provide access to information that supports business retention and growth, and including today's program, which is a product of our Energy and Environment Committee. I want to give some special thanks to the Energy and Environment Subcommittee members who helped organize today's program. Bob Baranowski with Highland Levin Shapiro, Sue Boyle with GEI Consultants, Dave Brewster and Steve Kirshner with Montrose Environmental. We really appreciate your help in putting this morning together. And before we begin, let me start with a couple of notes. We plan to have approximately 10-15 minutes at the end for audience participation with questions and comments and answers. At that time, Sue Boyle and Steve Kirshner will ask you to use the raise hand feature, and they'll call on you to unmute yourself for your question or comment. So until then, if you would, please remain on mute so that you avoid distractions. We're recording the meeting and we'll share the email, the link, and to the replay and the slide presentation. And you'll also receive a link with the program book that includes the directory of today's attendees and their contact information. That way it will help you network and connect with one another. I want to thank the sponsors of today's program. We have Atlantic City Electric, and Susan Cohn is with us, and you'll hear from her in a minute. GEI Consultants, Sue Boyle, Highland Levin Shapiro, Bob Baranowski, Montrose Environmental, Steve Kirshner. Our host sponsors, Performance Marketing, Glenn Davila, and PCS, that's Anthony Mongalizzo. So with that, I want to introduce Susan Cohn, who is our presenting sponsor of today's program. And she's also the co-chair of the Energy Environment Committee, as well as a member of our Board of Trustees and our treasurer. So with that, Susan.
Thank you, Jane, and good morning, everybody. It's my pleasure to introduce our speaker, DEP Deputy Commissioner Sean Moriarty. Sean serves as Deputy Commissioner for Legal, Regulatory, and Legislative Affairs to Commissioner Sean LaTourette. He leads DEP's internal legal team and serves as its general counsel on all matters of regulatory and compliance and rulemaking. And he will oversee the newly created Office of Enforcement Policy. Previously, Sean served as Chief Advisor for Regulatory and Legislative Affairs at DEP. Before assuming this position, he was the director of the Office of Legal Affairs after several years as a regulatory officer with the Bureau of Legal Services and Stewardship for the DEP's Green Acres program. Before joining DEP, Sean represented the department as a Deputy Attorney General. Sean, it's an honor to have you join us today, and we are looking forward to your remarks. The floor is yours.
Thank you. Thank you. And I assure you the honor is mine. And the honor is the department's to be able to work on such an important topic as environmental justice, and ultimately to be able to implement first in the nation environmental legislation. And we're going to spend a bit of time talking about that. Before we do, I just want to highlight that the issue of environmental justice is broader than just what we're going to talk about today with regard to the legislation, with regard to the ultimate rulemaking. And we are looking both inward and outward and trying to take a whole of government approach to address the issue. Working under Governor Murphy's Executive Order 23, issued within the first 100 days of office, in addition to our rulemaking efforts in October of last year, almost a year ago to today, the department issued Furthering the Promise, which is our guidance document for how each of the state agencies across state government, how we're going to advance environmental justice issues. So there's more to be done. The topic is broad and multifaceted. Today, we're going to focus specifically on the legislation. I'm happy to do that. That is, at this point, my primary responsibility at the department. Next slide, please. So specific to those rulemaking efforts, this year we completed what we consider to be basically the gold standard of departmental stakeholdering. something that was warranted and necessary given the novelty of the issues at play here with the environmental justice law, which we believe helped inform our ultimate implementation of this law. We held multiple sessions, each diving into some level of depth on these specific topics. And we aim to meet this level of engagement where appropriate on, rulemaking going forward, making sure that we are hearing from the regulated community, hearing from our advocates, and understanding really the issues at play. I will tell you the ideas that we had when we started when we started a year ago today with our first public information session are not the ideas we are going to end with when you see the proposal in the New Jersey Register sometime towards the end of this year, early next year. So we really have informed and changed our approach based on the feedback we've gotten. I think we're in a much better place as a result of that. Next slide. So let's talk a little bit about what the environmental justice law means and why the legislature and why, in his wisdom, that sponsor Senator Singleton wanted to move this forward. And what we see is that the environmental justice law recognizes that environmental standards are often formulated on the effect pollution has upon general populations spread over wide geographic areas, and that those existing laws fail to fully consider the impacts that certain facilities might have on their local communities, particularly when in abundance. This failure has created pockets of high pollution across New Jersey, where many of those facilities have become concentrated in predominantly minority and low-income communities that may ultimately lack the financial and political power to shape their local landscape and avoid disproportionate impacts on their public health and environment. Next slide, please. We think that this is reflected in the findings of the legislature in the environmental justice law. I think that's an important first step to understanding the intent. We do that by looking at those declarations. Couple that jump out to me. Historically, low-income communities and communities of color have been subject to disproportionately high number of environmental and public health stressors, including pollution from numerous industrial, commercial, and governmental facilities located in those communities that we talk about with the abundance of facilities. And ultimately, this legacy of siting has and continues to pose a threat to their health, well-being, and ultimately economic success. And in that, the legislature believes that it's time to correct what they are calling an historic injustice. Next slide, please. And as we continue to look through these, you're looking at findings with regard to the disproportionate share of those consequences of our state's economic growth, and finding that it's in the public interest of the state under appropriate circumstances to limit the future placement and expansion of facilities in overburdened communities. That is ultimately our charge in putting together the regulations. Next slide, please. So now that we understand the premise of the law, let's kind of talk quickly about how we plan to implement it. At its most basic, the law requires us to consider whether a specific facility seeking one of the enumerated permits in the law will contribute to environmental or public health stressors in an overburdened community, considering whether and how those stressors might have a disproportionate impact when compared to the overburdened communities' neighbors. And we'll get into a little bit of detail on what all of those terms mean, but that's kind of the shorthand thumbnail sketch of what we're going to be doing. Ultimately, how we define each of those pieces is the crux of our rulemaking effort. We begin by defining where the law actually applies. And to do that, we use a three-pronged test of applicability. The first is whether the facility in question is one of the 8 types of facilities listed in the bill. It's important for folks to understand that while this law has potentially game-changing potential in its implementation, the scope of the bill is actually fairly narrow when you start to look at it. We are only looking at 8 types of facilities. Those include major sources of air pollution, incinerators or cost recovery facilities, large sewage treatment plants, transfer stations and solid waste facilities, certain recycling facilities, scrap metal facilities, landfills, and medical waste incinerators, except those attended to hospitals and universities. The legislature has given us these broad categories, and it is our job to ultimately fill in the details of those. And our approach for these facilities is to incorporate the existing definitions where appropriate, with certain modifications that are necessary from our existing regulatory structure. Now, this may include, in some places, modifying a regulatory cross-reference to ensure the definition matches the statutory charge, such as ensuring that medical waste and sludge is included in the definition of incinerators. We're building new definitions for existing concepts, sludge from our Egyptes or scrap metal from our solid waste rules, or new definitions like sludge processing facility. ultimately ensuring that those definitions match as closely as possible the legislative intent while drawing from the information that we already rely on and that folks already understand us to use through our existing regulations. Next slide, please. So the second question we ask ourselves, Esther, is it a covered facility? Is one of those 8 types of facilities? So that facility is seeking one of the subset of environmental permits, including solid waste and recycling, development, including our wetlands, CAFRA, flood hazard permits, water supply and pollution, or air pollution and pesticide permits. If that facility is seeking one of those permits, it's potentially covered by the environmental justice regulations. It's important to note here that the bill excludes authorizations or approvals necessary to perform remediation or minor modifications to major source air permits that do not increase emissions. Again, really kind of setting the arena for which we're going to be working when we get through the environmental justice regulations. Our approach here is essentially to define and incorporate the permit definitions and thresholds present under our existing regulations. Again, to maintain some consistency and predictability to implementation while ensuring that we're meeting the statutory intent. Next slide, please. And the third prong of our 3-prong test of applicability is whether that facility, one of those 8 enumerated ones, is seeking a permit. Again, one of the ones we talked about is located or proposed to be located in an overburdened community. The overburdened community is defined as meets one of 3 criteria shown here on the screen. Those being, and we're using census blocks here, the finest point of census data available. So you're looking at census blocks where 35% of the households are low income. That's defined as at or below twice the poverty threshold as determined by the Census Bureau. 40% of households identify as minority. Those would include residents that identify as minority or members of a state-recognized tribal community, or 40% of the households have limited English proficiency. And those are households that do not include an adult that speaks English, quote unquote, very well in accordance with the Census Bureau. A couple of things to focus on here. First is the use of the word or. That means the most expansive protections of any block group that meets any one of those criteria is considered by the legislature and by the legislation to be an overburdened community. We'll talk a little bit about how we're going to ultimately implement that. Also, as I noted, we're using census blocks, which is the most finite unit of neighborhood census data available. We think that the broad and expansive protections of the use or with the specific focus on census block group really does strike the right balance of getting at the people most in need of the additional protections under the Environmental Justice Bill and its ultimate regulations. And we'll talk a little bit again about how we're going to do that. Next slide, please. So this just gives you an idea of what the overburdened communities look like in the state. This is analysis done on the most recent census data available. We've made that information available on our website through a mapping tool, and Julia Wong, who's joining us today after my presentation, is going to walk you through a little bit about how that's going to work. And you can see here, ultimately, when you add up all the block groups that meet those specific census criteria, we end up with over 3,000 block groups and approximately 4 million people covered under the statutory definition. Next slide, please. So now, once we determine the applicability of a particular project, the bill then requires an analysis of the environmental and public health stressors that community currently bears, many of which are defined expressly in the legislation. Now, it's important to note here, and you can see on the screen, the use of may cause when discussing public health impacts, and what that means ultimately from a data and rulemaking perspective. What this does is it allows the department to consider present conditions that may, provided we have a scientific basis to determine, contribute to those conditions. So present conditions in a community that might contribute to asthma or cancer, elevated blood levels. As we go through our stressor analysis, we are looking at things like age of housing, water quality data, presence of lead service lines, proximity to highways, other present conditions that might impact these. That means we are not required to use specific data that might not otherwise be usable or available related to asthma rates in a particular community. It gives us more flexibility. I think allows us to use data that's more publicly available and more scalable in the way that we need it to be able to get at the things that the legislature is concerned about. When you talk about environmental stressors, you're looking at concentrated areas of air pollution, mobile sources of air pollution, contaminated sites. And one thing to note here is that the legislature specifically defined environmental or public health stressors to include the presence of those facilities. So the facilities that we've talked about under the facility definition, transfer stations, solid waste facilities, recycling facilities, scrap yards, those things are included as environmental or public health stressors. So we have looked at that to consider the density, ultimately consider the density of those facilities as being related to this definition. We'll talk a little bit about that as we move forward. Next slide, please. So how do we fill out those broad statutory categories? We did so by developing a brainstorming list of stressors. We looked at past efforts the department had conducted, including our 2009 preliminary screening method, to estimate cumulative environmental impacts, to similar efforts, in 2012. The stressors discussed in our EO23 guidance, furthering the promise, which we talked about earlier, and other tools that provide similar data like EPA's EJ screen and California's Enviro screen. We also talked extensively to our programs who are ultimately the real experts on these specific data layers, experts on what these facilities look like, and input from our stakeholders. We then narrowed that list down, and we're now considering using somewhere in the range of 30 stressors, and considering a couple of things in selecting those stressors. First, alignment with the categories in the EJ rule, the things we just saw on the first slide. So do these stressors inform concentrated sources of air pollution in an overburdened community? We're looking at data availability, whether that data is available statewide and usable in the way we need it to be. We're looking at data quality. We've considered how reliable that data is and whether we feel like we can use it from a rulemaking perspective to ultimately make regulatory decisions. Whether we can manipulate that data down to the appropriate geographic scale. For it to be usable, it needs to be reliable and available at the census block group scale, which is easier said than done. Our ability to ultimately quantify that data, and then a marginal value analysis, considering a number of stressors and whether adding those stressors from the 60 plus initial list actually provides value in our analysis. We're not looking to just include more stressors that are completely overlapping and completely redundant. So as we add stressors, we consider how that ultimately affects the outcome of our analysis to make sure it is accurate as it can be in providing the protections necessary under the environmental justice law. As we move forward, there's going to be some overlap, and we'll walk very, very quickly through the list of stressors. I like to include this in the PowerPoint so folks have it for reference, but I'm not going to discuss each of these in detail given the time we have. So we can just go to the next slide. To just to give you an idea when we're looking at concentrated areas of air pollution, these are the types of things we're looking at. NADA data related to cancer and non-cancer risk, diesel related information to try to capture the impacts of truck traffic, PM 2.5, ozone. Next slide. Considering major sources of air pollution, similarly looking at truck traffic, looking at proximity to roadways. We were considering whether it's appropriate to include a warehouse layer because of the impacts of warehouses on and the associated truck traffic on surrounding communities. Next slide. Considering point sources of water pollution, looking at CSOs, looking at NJDC sites, looking at water quality data. Next slide. Solid waste and scrap yards, again, looking at the density of solid waste facilities and scrap yards in a particular overburdened community. Next slide. Similarly, looking at contaminated sites as they have the potential to have legacy impacts on overburdened communities, as well as present day impacts if they're not properly remediated. Next slide. Looking at certain conditions that might affect public health issues in a community, age of housing, extraordinary hazardous facilities, water quality, total regulated facilities. Next slide. Looking at lack of open space, lack of tree canopy, being particularly aware of the impacts of heat island effect and the worsening impacts of that effect in overburdened communities as we continue to face the effects of climate change. Impervious cover also relevant to that, and flooding again relevant to that analysis. Next slide. We're also considering whether to include certain social determinants, poverty, unemployment, education, minority status, limited English proficiency. Recognize there is some overlap there with the demographic criteria set forth in the statute, but certainly taking into account what the inclusion of those stressors might mean to our analysis. Next slide, please. So now once we've determined what those stressors are, the law requires the department to determine whether those stressors are quote unquote higher than those borne by other communities within the state, county, or other geographic unit of analysis as determined by the department. What we're currently considering here is what you see in the green text. We went through an analysis of whether the appropriate, and this is harkening back to what we talked about, the neighbors. Who are we comparing this to? We looked at state and county individually. We looked at state excluding the non-overburdened areas, so taking out the areas that have not been, in the words of the legislature, potentially subject to this legacy of siting on both the state and county level, and ultimately settled on what we think is the appropriate approach, which is the hybrid of those. It's most like what EPA uses, uses multiple geographic areas, considering the lower of the state or county, excluding those non-overburdened communities. And when we be considering what percentile we would use to consider what is higher than, we're using the 50th percentile. So essentially looking at the median or average across the non-overburdened communities as a point of comparison for the overburdened communities. Go forward a couple of slides. Go through one and then one more, please. So as you can see here, oops, sorry, hop back one. Thank you. So what this slide shows is what the hybrid approach looks like when you do that. What you see here, the areas in blue are the areas that are ultimately covered by our analysis. When you look at the individual stressors, when you use the lower of the two as a comparison, we're covering somewhere between 80 and 90% of the block groups, and ultimately avoiding exclusion of block groups in the north and south that would fall out if we used either of those criteria alone. If you have time to look at the slides, you can see if you consider only county or state, you start to lose protections, particularly up in Hudson County, where those counties are, particularly stressed, as well as counties in the south where they are comparatively less stressed, where if you're only using a state comparison, those overburdened block groups would end up falling out of the analysis. So recognizing that lack of statewide consistency when making those comparisons, we are likely to move forward with the map on the right, which is that 50th percentile, the lower of county and state OBC. Ultimately, believe this is the fairest and most equitable approach, as it recognizes both the strong correlation between our statutory demographic criteria and the environmental and public health stressors, and the need to ensure equity for individuals living in both comparatively more and less stressed counties. We're going to talk a little bit about how we're going to fine tune that analysis and what we're going to do. Next step. Next slide, please. So we've talked about kind of the basic things that we'll be looking at. Now let's talk about how we go about that analysis at a pretty high level. In order to move forward through our process, an applicant needs to complete an environmental justice impact statement that assesses the potential environmental and public health stressors associated with that facility, new, expanded, or an existing major source facility that's seeking renewal, including any adverse environmental or public health stressors that cannot be avoided if the permit is granted, and the environmental and public health stressors already borne by the overburdened community. So you're looking at the facility, what those stressor levels are informed by the data we've already discussed, and how the facility might be able to avoid those stressors, and if not avoid those under certain circumstances, how they might minimize impacts of those stressors. So next slide. Let's talk about how we work through that. So what we're using is something called the combined stressor total. So what you do in this situation is that you look at each of the stressors in an overburdened community and determine whether that is higher than that most protective geographic point of comparison, state or county non-OBC. Higher than means, again, greater than the 50th percentile. What we would do in that situation, we sum the number of stressors that's higher than the geographic point of comparison. That's how you get your combined stressor total. So for example, if 18 of the 31 stressors in an OBC are higher than geographic point of comparison, the combined stressor total for that overburdened community is 18. Then you determine if the CST, or combined stressor total, is again higher than the geographic point of comparison for the state. Again, using that same analysis, that 50%, that lower of county and state. So in this example, if the OBC's CST is 18 and its geographic point of comparison is 15, again, the average of non-OBCs across the state are 15 out of, in this example, the 31 stressors or higher, that OBC is subject to adverse environmental or public health stressors that are higher than a geographic point of comparison. That's our initial screen. That's the first step. Next slide. Where the CST might be lower, so an example where that CST for that community is lower than the 15, the applicant prepares an environmental justice impact statement, conducts a public comment period and a hearing, and ultimately needs to assess whether that facility will contribute to those existing environmental and public health stressors such that it creates stressor levels that are now higher than the geographic point of comparison. If it doesn't, then it avoids a disproportionate impact, and the applicant is able to move forward with the normal environmental permitting process without additional conditions and without additional process under our environmental justice regulations. If it will, or if that CST is higher, so if it is or will be made higher, then the applicant is required to do what we're going to call supplemental materials under the environmental justice environmental justice impact statement. That would include a public comment period, and this can be done concurrently, and holds a public hearing, and ultimately assess how its contribution to those stressors can be avoided, minimized, and in certain situations provide a net environmental benefit for a particular. Next slide, please. So those supplemental materials would include a bit broader of environmental analysis, as well as an alternatives analysis and a discussion of the specific environmental justice related conditions that a facility would propose to be able to avoid or minimize its contributions to the environmental or public health stressors in that overburdened community, which are higher than the geographic point of comparison. Next slide, please. So that gets us into the kind of the end game here, which is, what are these permits? What are the permits under these regulations? What will they ultimately look like? How are we going to move through this? And it's important to understand here that the department has different authorities and a different ability to affect permits depending on whether the facility is a new facility or an expansion. For new facilities, the department is required to deny a permit, except where we determine if there's disproportionate impact, except where that facility will serve a compelling public interest in the community where it is to be located. We'll talk about what that means. For facility expansions or Title V renewals, the department is empowered to provide conditions to the permit for the expansion of the existing facility that are necessary to protect public health. Next slide. So we look to define new and expansion and renewal. We think this is pretty straightforward. Continuation of existing activities would be considered renewal. Increases or expansions in footprint would be considered expansions. And any new facility, or ultimately a change in use, a significant change in use for existing facility would be considered a new facility. And then we would apply those conditions as set forth previously. So next slide. So depending on whether we have a new, renewed, or expanded facility, these are the types of things we'd be asking a facility to consider. For new facilities, we'd be looking at measures to avoid contributions to individual stressors. If they can't avoid, that again is denied unless there's a compelling public interest. If there's a compelling public interest, we would apply certain conditions. For renewals, we'd be looking at measures to avoid contributions. We're also looking at appropriate, objective and understandable analysis that facilities can use, particularly Title V facilities for their stationary sources that they'll be able to work through, hopefully in an objective and predictable way to determine what they need to do to avoid and or minimize. Where avoidance is not feasible, we're looking for facilities to minimize contributions to the maximum extent they can, again, using a feasibility standard. For expansions, we'd be applying similar conditions what we'd apply to new facilities. We'd be looking again, first at avoidance, second at minimization, and third, where appropriate, additional feasible conditions that could reduce stressors from offsite sources, could reduce other stressors in communities, and ultimately ones that might provide a net environmental benefit that improves baseline conditions and public health stressors in an overburdened community as a condition of expansion. Let's talk a little bit about, next slide, please. What compelling public interest means. Again, this is the place where there's an exception to how new facilities need to be handled, where a new facility that might contribute to adverse environmental and public health stressors in a community can be permitted. It has to satisfy the compelling public interest standard. Here we'd be focusing on specific types of facilities and public works type projects that serve a compelling public interest in an overburdened community. Examples that we've talked about during our stakeholder holding include appropriately scaled food waste facilities, public water infrastructure, renewable energy facilities. We'd be considering whether those facilities meet essential health and safety needs of the overburdened community, or specifically reduce stressors, thinking about ways in which combined sewer overflow issues might be reduced. And we're not allowing for economic benefits as a strict justification for compelling public interest. We would also consider, we think it's appropriate, to consider whether there is a significant degree of public interest in the overburdened community in favor or in opposition to the facility. I think it's important for folks to have a level of self-determination in this process, and to ultimately meet the charge of the environmental justice law, which is to provide meaningful public participation. Next slide. Again, this goes just a little bit into what we talked about in terms of what the conditions are. They largely mirror what we'd be asking for renewal facilities, just through the compelling public interest lens. And with that, I'm about at time. Last slide, please. Just like to end here with a very large plug for our environmental justice webpage. That contains all of the information that we've talked about today. It contains all the slideshows we use at our stakeholdering. It contains very, very long videos of me talking for much, much longer than I'm talking today. as well as copies of environmental justice law, our administrative orders, our environmental justice guidance, and everything else that we think is really, really important in this space. So thank you all for your time. Julia, I believe you are up.
Thank you, Sean. We appreciate walking us through this. We're going to, as you mentioned, now have Julia Wong join us. Julia works in the Office of the Deputy Commissioner, Legal, Regulatory, and Legislative Affairs, advancing the department's policy goals, specifically surrounding environmental justice, climate change, and solar energy. She previously worked at the DEP in the Office of Environmental Public Health and Safety as a data analyst, and in the Office of Brownfield and Community Revitalization, largely supporting the Community Collaborative Initiative. Julia is going to share her screen and give us an online tools demonstration of some of the topics that were covered this morning by Deputy Commissioner Moriarty, including locating a site, determining if it's within an overburdened community, and helping determine the communities that are impacted. And so with that, I see her screen is shared, and Julia, thank you for joining us this morning.
Thanks so much for having me. Quick plug for what Sean was just talking about. This is our environmental justice website. And if you go to this tab right here, the law, policy, and regulation, you find all of those lovely videos that he just mentioned. And he was not joking about it being hours and hours of him talking about this. So should you like more information, that's where you should head. But otherwise, yes, quick run through of some of our tools that we're promoting. Again, this is our environmental justice website. Instead of going here, if you go over to the overburdened communities tab, I've preloaded things in case I have internet issues. You get this screen. Scrolling down, you have a little bit more information on the OBCs, which Sean just covered. Again, the definition here, this incredibly handy map that I reference basically every day. And then scrolling down a bit farther, you have these 6 tabs. These 2 at the bottom are more information, but these 4, the red, yellow, green, and blue, are more different ways of viewing this information. The first one is an Excel spreadsheet. It's the one that I probably use the most frequently. Download the data, you can manipulate it, sum totals for population tabs, those sort of things. The second one is the environmental justice mapping tool, which we're going to get into in a little bit. This third one is a PDF maps of all of the municipalities. So should your municipality have even one overburdened community within its borders, you can download a map, reference it, print it out, really easy to use. And the last one is probably the most technical, which is a GIS shapefile. So if you have a GIS savvy person on your team, download it, you can manipulate it, layer it with whatever other shapefiles you have. So going into this mapping tool, what'll pop up is this first screen. Sounds great, click accept. If you want some more information and background on the law, you have this about tab over here, a little bit of information on how to use the tool itself. I'm just gonna X out of it, because we're gonna go through, and you see our lovely state. On the left-hand side, you have our legend. So these different colors represent the different combinations of categories that can qualify for an overburdened community. Those 3 categories being the minority, low income, or limited English proficiency, and any combination thereof. So you can see on the map, the different colors correspond to the different categories. Zooming in a little bit, scrolling over, here's just a random town that we zoomed in on. You can see that these are all the borders of the municipality, of the municipality here in gray, and then these are the individual block groups. I'm actually going to switch my base layer because I find it a bit more, easy to see using a different version. So imagery hybrid. Again, you can see, oh, this looks like some parkway, green areas. Maybe there's a park over here, downtown residential area, perhaps, those sort of things. And I'm also going to add on, using this from the layer list, click on municipalities. I am not as familiar with some of these municipalities as others. So now you see that the red lines are outlining a given municipality. My favorite function of this tool is actually just searching It makes it the easiest, I find. So up here on the top left, find address or place. If I had a specific address, I could type that in. Instead, for now, we're just going to type in Voorhees and see where that takes us. So the map automatically recentered around Voorhees, and you can see that this dot is marking the center of the town. I'll zoom in a little bit more and just explore around. Actually, I'm going to change the base layer again. This isn't working for me. OpenStreetMap. There we go, a little bit clearer. So you can see here again, we've got the blue, the green, the orange designating different forms of overburdened communities. I can click that back up in case you want to see what they are. And let's click this blue one. So this should be low income and minority. You can see that it's listed here as the overburdened community criteria that it met, the block group identifier, and then the town and county that it's in. Depending on what sort of screen size you have that you're viewing this information on, this table can look a little funky. So you can always maximize it, and then it gets a little bit big, but more easily you can see the table that has population, total population, the ones that meet all of the different OBC criteria, etc. And then let's click a different color. Low income, the beigeish orange color. Again, here's all the information. So for instance, if you were exploring Voorhees and you have a facility that already exists in, let's go back to this one, blue, low income and minority. If it's the new facility that you wanted to put in, it would be denial unless it's a compelling public interest, as Sean had discussed. If it's an expansion or a renewal, it would meet all of those environmental justice impact statements, potentially the environmental justice impact statement plus supplemental materials, all the stakeholdering, etc. Great. We can explore another town as well. Let's head to Hamilton. Ooh, let's go Hamilton Township. Maybe that'll be clear. And now here again, you have the red border of the municipality, a couple of different OBCs. Let's click here, see it qualifies for minority, and then all of the population information. Another thing that I like to see, or another way that I like to view the data is down here, this, I don't know if you can quite see it on the share screen, but there's an arrow that goes up. If you pop it open, it has that same information that's in the table, but just visible on your screen now. So as you scroll, the data table should update as well. It has all that information, can filter, zoom, refresh. You can also just view by different sort of metrics across the top. And if you wanted, you zoom in very close. All of the block and lot data will pop up. And clearly my internet's being a little bit slow, but let's see if this works. And you click on one, what should theoretically happen is it pops up information on owner and some other pieces of things that are slipping my mind right now. But if you wanted to, there we go. So if you wanted to contact, I have no idea, I clicked on a random block and lot, but you're interested in buying this piece of land, you want to develop something on it, you know who owns it, so you can reach out and contact, and then some of the other property information. So that's about it that I have for the demo. I find it pretty intuitive. There is helpful tips and tricks, particularly this information bubble up here. If you, or sorry, not this one, the help feature through ArcGIS Online. If you have any questions, they can help. But other than that, happy to answer any questions or pass it back to presenter so you can get to the meat of the presentation.
We just to add to what Julia said. So what we're ultimately going to be able to use that data tool for is all of those stressors that we talked about are all going to be loaded into that data tool. So what Julia showed you now, where you're able to look at the demographic criteria and some of that information is going to be supplemented with a list of all the environmental and public health stressors in each of those block groups. So you'll be able to do, as you know, anybody who is going to be interacting with the environmental justice regulations, is to be able to go through that initial screen step we talked about and look at the each individual stressor layer for that block group through our online tool. I think that's going to be really, really easy and convenient and a perfect way for folks to be able to efficiently and objectively move through that information as you go through the environmental justice process. So when we propose the regulations, at the time we propose the regulations, we're going to put out a beta version of that information that what Julia just went through will be updated to include all the information that we have validated at the time. You'll be able to look at the combined stressor total. There'll be a table that will come up similar to what Julia showed with the ownership information, which will have all the stressors and their comparison points. So you'll be able to, on one screen, see all that information, as well as underlying guidance document, which will explain to folks, particularly folks who are more technically inclined, how we derive that data and ultimately what the analysis will be asking to be done under the regulations will be. By the time the regulations are formally adopted, all that information will be completed and we'll have a coherent, consistent data set for all of our stressors for every block group in the state that will be publicly available and hopefully easily usable.
So just to anticipate a question, the beta version you expect will be available when?
When the regulations are proposed, which we think will be the end of this year.
Yeah.
We're in the final stages of drafting.
Okay. Terrific. Well, thank you. Thank you, Julia, very much for that demonstration. We really appreciate it. Lots of information on that DEP site that helped you, again, understand the rules, the regulations, and then in the case of what Julia just demonstrated, some of the tools that are available to help you understand whether or not your project, your potential project is in one of these overburdened communities, and then how to proceed from there. So what I want to start to do now is we've invited some industry experts to join us for a discussion on how the law will impact specific industries, how it'll be implemented with existing land use and zoning at the local level, and really how to effectuate community outreach. Just as a reminder, again, following the panel discussion, we'll leave 10-15 minutes to engage the audience in the conversation. And so with that, it's my pleasure to introduce and turn the program over to the moderator of the panel discussion, Rutgers Law School Dean Kim Mutcherson, who will introduce her panel guests. Kim is an award-winning professor whose scholarship focuses on reproductive justice, bioethics, family, and health law. She has presented her scholarship nationally and internationally and publishes extensively on assisted reproduction, families, and the law. As co-dean of Rutgers Law School in Camden, she leads New Jersey's public law school with a globally respected faculty, and I understand is in Collingswood, as am I.
That is right. Thank you so much, Jane. Thank you for having me here. I have already learned a tremendous amount in just a small bit of time that we've been on here, and so I'm excited to hear more from everybody. So our panel is going to consist of Deputy Commissioner Moriarty, who's going to be back, and then Bob Baranowski, sorry, Bob, who is a partner at Highland, Levin, and Shapiro, where he concentrates his practice on environmental and land use matters. He represents clients in connection with development applications, zoning and land use litigation, appellate matters, redevelopment, eminent domain, and inverse condemnation actions and administrative proceedings. So a very busy man. Our second panelist is Dennis Hurt, who joined the Chemistry Council of New Jersey as its executive director in November 2016. His career spans more than 4 decades, with most of it spent at the New Jersey Department of Environmental Protection, where he started as an enforcement case manager in the Division of Water Resources, rose to the rank of Assistant Commissioner of Environmental Regulation, and later administrator of the New Jersey Water Supply Program. And then Carlos Rodriguez, who is a past president of the American Planning Association New Jersey chapter and is a principal of Design Solutions for a Crowded Planet, LLC, a Princeton-based urban designer, planner, and educator. He represents public, private, and nonprofit clients on a wide range of planning, sustainability, design, research, and educational initiatives of merit. So I'm going to actually open up with you, Bob, if that's okay. So you had an opportunity to hear remarks from Commissioner Moriarty. And so I'm curious to hear from you where you feel like we stand today in terms of the statute and the administrative order, and whether all the sort of key definitions have been covered, or are there other things that you think people should be thinking about now?
Thank you. Thank you so much, Dean Mutcherson, and thank you to Deputy Commissioner Sean Moriarty and to Julia Wong for that really super informative presentation on the environmental justice law, and particularly that discussion of how the law and policies were developed and how they're going to affect the regulated public. And that mapping tool is really amazing. And the environmental justice page of DEP's website is very informative. I grew up in that section that's all covered by dark blue in Hudson County. Was not shocked to see that. And I don't think you could have better serendipitous occasion to bring up a random property in South Jersey and find the owner's name was Country Blues LLC. So that was it's well done presentation by Julia there, and it really is going to help to take the mystery out when dealing with a permit application and how it's going to be affected. And how the regulated public will be affected and how to deal with it. So I think Sean and Julia already took a pretty deep dive into the basic elements of the law, covered what types of facilities and permits will be affected and subject to the new process, how to determine whether a regulated activity is taking place in an overburdened community. So I think it would be helpful to jump into a discussion of another component of this legal framework, and that is the administrative order that was issued by Commissioner La-Tourette on September 20th, 2021. That's AO 2021-25, and you can find that right along the top banner on the department's EJ website. And that declares the department's intention to implement the environmental justice law now, immediately, before any rulemaking is finalized, which takes some time, to the extent allowed by existing law. As Sean mentioned, under the environmental justice law, the department must adopt rules to fully implement the act, which we all know is going to put more meat on the bones about the process. But under the act, the department also has authority to issue technical guidance regarding compliance with the act, similar to what we've seen in more recent statutes, environmental statutes, such as the Site Remediation Reform Act. And that gives, I think, the department the ability to be a little more fluid and responsive in real time by publishing guidance rather than going through a more onerous Administrative Procedures Act, process. But I think the department balances those things out and acts accordingly. So I'm trying to put on my Deputy Attorney General hat that I took off 20 years ago, and this is what I think I see happening. So guidance itself is like a policy memorandum or a similar type of document used by an agency to provide technical or regulatory assistance and direction to the regulated community to facilitate compliance with the law. So here, the commissioner has issued an administrative order, may or may not technically be what we would typically consider guidance in a technical sense, but it certainly gives guidance to the regulated community how DEP intends to implement the environmental justice law now. And the key takeaway that I see from this order is that DEP is moving full steam ahead to effectuate the purposes of the law, particularly with respect to the public participation process. So I think what we can expect now immediately is a more robust public participation process and a need to address any concerns that are raised. And the focus of those efforts are found in the language of the administrative order, which mirrors the language of the law. It says DEP intends through the permitting process to provide meaningful opportunities for overburdened communities to engage in permitting decisions for pollution generating facilities through an enhanced public participation process. So we look at that and we look at, what does that mean? And in the administrative order, it spells it out. It's going to include longer public comment periods, public hearings on all subject applications, requirements for applicants to address issues that are raised and how adverse effects might be avoided or reduced. And we heard Sean speak to that as well. The AO, the administrative order, it applies to all pending permits with open comment periods and moving forward. So this is live. I mean, the department is telling us this is going live. So, if you take a look, the administrative order is available on the webpage, and you can go through some of the specific orders that the commissioner has detailed. Public comment periods shall be no less than 60 days, regardless of any other minimum timeframes established under applicable rules. Can be expanded by an additional 30 days upon request by a member of an overburdened community. Each applicant has to hold a public hearing. Information regarding existing conditions in overburdened communities will be discussed and considered, taken into account, and the applicant will be required to respond and address concerns that are raised. And another key aspect of this, and it's one I hope we can discuss on the panel today, is the requirement for the applicant to engage directly with individuals in the community, find out the concerns, and then again, as Sean mentioned, all of this is anticipated to lead to special conditions potentially being imposed on any approval of any permit application for new or expanded facilities. So, again, the takeaway is that the process is meant to give affected communities a voice, to put the public in the room where it happens, and to have applicants listen and respond. And regulated facilities and overburdened communities need to plan accordingly to engage in the process and develop strategies now for enhanced community outreach and to take meaningful actions that will effectively address the types of concerns that are raised during the process. So Dean Mutcherson, I think that about covers what I would try to add to that conversation, which I found to be very helpful by Sean and Julia. So thank you.
Terrific. Thank you so much, Bob. Dennis, I'm going to jump to you if that's okay. And we'd love to hear you talk about the top concerns of the regulated industries here. There's a lot going on here.
Sure. Thank you, Dean Mutcherson. I appreciate it. And thank Jane. I think this is a really good program here today. I really thank you for the opportunity to participate. The Chemistry Council of New Jersey, we represent chemical, pharmaceutical manufacturing, refineries, flavors and fragrance facilities. And once, as this legislation was moving forward, once amendments were made that allowed existing facilities to continue to operate while the environmental justice process took place for renewals and expansions, we supported the legislation. I think we were one of the only business associations to actually support environmental justice legislation, and we took some small amount of heat over that. But as our corporate members, we agree with the issue of environmental justice. Many of our facilities already have existing community advisory panels with professional facilitators to work with the community. So for the most part, we are doing some of this, but there is some difficulty that we see and some headwinds for us in industry. When I think about environmental justice, historically, I always think of it as, why in Camden County does this major sewer authority, does the garbage incinerator, the sludge incinerator facilities always have to be in Camden City? Why were they never spread out throughout the county of Camden? And that's what I think of about environmental justice. It was, well, it's easier, the land is cheaper, or let's put it there, and the people will be happy, we're giving them jobs. And I was involved when I was at DEP, it's been unfortunately about 20 years ago now, when a company called St. Lawrence Cement sought a permit to locate a facility at the Camden port where they would be bringing in materials for making cement and bringing materials. We're offering jobs. Hey, this is great. We're bringing jobs into a poor community. Let's approve this project. And I'm not even sure that project would even be covered under this existing legislation right now. But the impact of that project was, within a short period of time, there were literally hundreds of dump trucks carting this material out of the port through all the back cities, streets of Camden, trying to avoid traffic and just causing a nightmare, both traffic-wise, but more importantly, air pollution-wise. And we ended up setting up monitoring stations throughout the city. And it took quite a while to come up with traffic plans and stuff to ameliorate the problem they were causing. So when I think of environmental justice, those are the kind of things. And I think that's the kind of things Sean has talked about throughout this entire process, is to just look at the things that are impacting a community and how can we do our best to reduce that impact or eliminate it if possible, and take into consideration. That's all easier said than done. what the DEP and Sean and Julia and everybody there and Olivia is trying to do is trying to make a pretty difficult program into a reasonable regulatory program. And it's not easy. And my message is it has to be an incremental program because we don't have the structure. I don't know if the department, who's already has overburdened staff, is going to have what used to be maybe the pollution prevention or the facility-wide permitting program will now be a environmental justice program to say like, hey, this facility is going to the environmental justice program. Can you guys put on the top of your pile the land use permit they need or the groundwater permit, or, so that the facilities that are saying, yes, we're going through this process, that they have a reasonable expectation that they're going to get through the process. I think that's the hard thing that we're going to see here. Now, what I hear is, and since this law was passed, I've had an unbelievable number of companies and associations around the country reach out and say, tell us about New Jersey's environmental justice program, because they're talking about it in our state and we're petrified. And quite frankly, the corporate world, while we all support it, are very afraid of what the department's going to do with the environmental justice program. As far as, while we understand there's no guarantees, we want to make sure that when companies, particularly New Jersey facilities, are constantly looking to their headquarters for investments, we'd like it, please invest in our facility so we can expand, so we can create more jobs, so we can keep our company here. Or if companies are looking to invest in New Jersey, there has to be, and I don't know what the right word is, but there has to be a reasonable expectation that if we're going to go through the process and we do everything, quote unquote, the right way, we're going to come out the other side with an approval to operate. And that's the hard part, that companies are looking and saying, do I take my investment dollars and go through this process in New Jersey, where we want to be good corporate citizens, but what's it going to be in an already difficult state to operate? What's the process and likelihood of us coming out the other side with an approval? Or do we want to go to Ohio or Indiana where they're begging us to come here and I don't have to do this stuff? That's the corporate world right now. So to the extent that, and I have to commend Sean and both Commissioner Latourette. I mean, they have been talking that throughout this process, that this is going to be a thing where we can work together, where we address community concerns. We can't tell you yes, no, if you do this, you do that. We're going to work together on it. But our overall fear is there has to be, a finish line that we can get to in a reasonable expectation of a time frame, or else a lot of part of our areas, they're just not going, the old industrial areas just aren't going to get those investments that we want. And the good paying jobs that we offer people are not going to happen without that process of reasonableness to get through. Because right now we know I don't think the department has the capability right now to do the overall regional environmental analysis of if this company is within this, if you're in Kearney and there's the turnpike and there's the Passaic Valley Sewage Authority, then there's the airport, and you're going to come in with a facility that's going to maybe increase your emissions from an existing facility or a new facility. How do you deal with that within this overall environmental issue that we have? Those things are going to take time, and if the process is incremental, I think we'll get there. But if it's a hard and fast yes, no, that's going to be difficult for industry to deal with. So I'll stop my presentation at this point right now, Dean Mutcherson.
Thank you so much for that, Dennis. I mean, well, first I want to say thank you for starting by talking about Camden City, which is where I've worked for 20 plus years. And so I appreciate the ways in which Camden has often received the short end of the stick, one might say. I actually think, Deputy Commissioner Moriarty, if you don't mind, it feels like this might be a good place for you to respond to some of the concerns that Dennis was just raising in terms of, industry being worried about how this is going to be implemented and therefore having to make decisions about whether New Jersey is a place where they want to build or expand.
Absolutely, happy to, and I'd be remiss if we didn't know consistently the support that the Chemistry Council has given for the environmental justice regulations. And I think what that shows is, and Dennis and I have talked extensively about this, responsible businesses, ones that are already doing this type of work, already doing this type of engagement, are going to have a competitive advantage in this situation. They already know how to engage with communities. They already know how to understand what the concerns are, and they already understand what they can do to address them. So what we're trying to do is ultimately kind of take that ethic of responsible corporate operation in overburdened communities, put that into the regulations, and create a process that is, and again, looking at the data tool, clear, objective, and as predictable as it can be, right? So by delivering publicly available data sets, we are all going to be on the same page with regard to what the environmental and public health stresses are in a given community, and what an individual business needs to do, and where they need to focus their efforts to address whether they're going to contribute to those environmental health stresses. It's not going to be a black box. It's going to be as open a box as we can possibly make. What we then go to is a conversation about feasibility of measures that can be put in place to avoid or minimize those contributions. It ends up being kind of as simple as that. And what our focus is in those situations is responding to the concerns as much as possible of the community, right? This is the hallmark of this is meaningful public engagement. It's understanding what the concerns are and addressing them to the best of our ability. The best of our ability is feasibility that considers the economic impacts of those conditions, whether in the short term or long term. So what we aim to do is create a process through the regulations that's as clear and objective as possible. One of the things that we're doing now, and what I am driving the rule team crazy about, is really just trying to push in places where we can define things in a way that will provide a level of predictability for everyone. It is not to our benefit to have people wonder what, for instance, feasibility means, or what we might be asking for with regard to conditions. If we need to be clear on that, we need to be clear, set the expectations for the environmental justice communities to know where they should focus their efforts, and for the regulated community to know where they should focus their efforts and resources. We think we can make that predictable. And then we think that the conversation we have through our Office of Permitting and Navigation, adding additional staff there, we're going to be focused on these specific issues. So we're going to be trained and have this be the thing they do every day. In short order, we're going to be able to develop a better understanding internally about what we can and can't do, what we can and can't ask applicants to do, and move forward. And I think one of the things that we'll be doing under the administrative order, which I know is something of much concern to many folks, is starting that conversation. And I think Bob summed it up very well. And Bob, it's good to see you. I followed in your footsteps as Deputy Attorney General. I've seen your name on a million things. I don't know if I've ever met you, but it's good to see you here. I'm also from Haddon Township, so I'm a neighbor of Gene and the Dean here. We're going to start that conversation, right? We're using our underlying authorities. We're looking at the intent of the environmental justice law and saying, how can we use those authorities to start to do some of this work, to start that conversation? And we think ultimately that'd be beneficial, right? We're going to learn, industry's going to learn. We'll probably make some mistakes. There are going to be some bumps in the road, but we're going to have built up some reps in this process. By the time the regulations go in place, we're going to find out where our weaknesses are, where our strengths lie, be able to assess those. So when the regulations are adopted, we're ready to go, which I think will ultimately be beneficial to the things that Dennis is talking about.
Great, thank you so much. I want to jump to you now, Carlos. And obviously, even if a wide swath of people agree that the goal here is a great goal, that the devil's really in the details. How is this all going to play out? So, can you talk about the impact that you foresee here on land use and zoning at the local level?
Yes, good question. I'm not sure I have a straight answer for that. These regulated facilities are either permitted uses or not, right? And so they will have to go in front of either the zoning board or the planning board. So there is a local process that is either going to happen before or after they deal with the department. Ideally, those two processes would be intertwined and they'd be talking to each other. But right now, I don't see any evidence that that's the intention. And that local process also has built in its own set of public hearings. So we have the potential for two separate public hearing processes going on either sequentially or in parallel. Again, ideally, they would be intertwined in some form or another, because there's only so much that needs to be said at public hearings. Now, admittedly, local planning boards and zoning boards are not frequently very sophisticated. I think that's a nice way to put it. And they certainly aren't looking necessarily at public health impacts of given facilities. So they could use some help. But right now, the way this seems to me, we have two processes that are running on parallel tracks. And it's really just a question of, and they're both run by government, state government and local government. I could see the benefits of finding a way to intertwine them a little bit better. If the department denies permits for certain facilities in certain locations, then, and they're permitted by the zoning, then the zoning is not going to make any sense and should be amended. So that is one potential outcome years down the road when these towns realize that they have that their uses that are permitted under their zoning are simply not going to go forward because they're no longer feasible, then that could be one outcome. Another possible outcome, and I'm not sure that this would be a favorable outcome, is that we start to see facilities migrate to census blocks that are not defined as overburdened communities. And we might have a facility sprawl, if you will, that's driven by this regulation. That would be unanticipated and undesired, but a possible outcome. So those are my thoughts. I have one additional thought, which is that that fantastic mapping tool could be enhanced by having a layer that shows where all the existing facilities are located. Because the department knows all of those regulated facilities, they know where they are. And I'm guessing that not every one of those 3,168 block groups has regulated facilities under this act. So to simplify things, just take those off the table unless there's a new proposal that comes in. Because if there are no regulated facilities in those block groups, then we don't need to fuss with them. And that's just a suggestion that I throw out. And then the other suggestion that I would make is that these environmental justice impact statements could be very, very pricey, and a boon to the planning community and the engineering community, no doubt, but they could cost a lot of money. And so to the extent that the department can sort of standardize and put out uniform databases upfront, that the AJ impact statement writers can then tap into and not have to do the legwork on their own, I think that would help to streamline the process and keep costs down. And that's all I have to say for now. Thank you.
There is a lot in there. Should I jump back to you, Sean? Do you want to respond to that? And I see that at least one person has started putting questions in the chat. Other folks should feel free to do that as well. We're going to open up in just a few minutes for Q&A, but I want to give folks on the panel an opportunity to respond to each other a little bit before we open it up to the audience. So Sean, do you want to go first and respond to Carlos?
Yeah, absolutely. And Carlos, thank you for those comments. All very well received and understood, where you're coming from with those. I mean, I think, as far as parallel processes at the local and state level, I think we see that a lot already in a lot of our land use permitting. Your zoning and planning at the local level versus coming to the state for your ultimate land use permits. They don't always align. We are looking at ways within the regulations to allow for, where appropriate, consolidation of public hearings and other things to make sure that we're not in this to create process for the sake of process. We're in this to create meaningful process that allows for meaningful public engagement. The key issue here is that the issues that we will be addressing in environmental justice regulations may be different than what is considered at a zoning here. If you're looking at whether this meets the specific zoning criteria in the municipality, is going to be a very different conversation than what we would, at looking at public health and environmental stressors. So it might not always be appropriate, but we certainly are open to and considering how we might be able to streamline that process, as well as streamlining as much as we can the environmental justice process with our existing permitting processes. We don't want to create, again, unnecessary process, but we also want to make sure that folks have reasonable expectation to be able to move forward with our permitting processes by being able to satisfy the environmental justice process. So we need to find a way to best harmonize those. On the last point, our data tool, our online map tool, is going to have all of the facilities. We're going to be able to consider, people are going to be able to see where everything is. And while I don't think we can just exclude those block groups. I think when you go through the analysis of the combined stressor total, that's where you're going to see that screening aspect of the regulations, where you're going to find that those block groups where those facilities don't exist are not going to be subject to a cumulative environmental and public health stressor level that's going to require them to go through this full process. We'll need to confirm that facility is not going to create that situation, but we are going to have significantly less involved process, less detailed environmental justice impact statement for those block groups that are not the ones we're really trying to get to, not the ones that have the abundance of facilities, that have high levels of PM, that have high levels of ozone, that are different, disproportionately, comparatively different than the need, right? That's ultimately what this is about. So I think we're cognizant of and trying to work through all those issues.
Thank you. So before we open it up to the audience, I just want to give Dennis and Bob and Carlos an opportunity to either respond to something that somebody else said or to what Commissioner Moriarty just shared, because again, there's a lot of information that's been put on the table here. So.
Hi, Dean Mutcherson, if I could, maybe kick off that discussion. I think a lot of what we're all talking about, it goes toward developing a meaningful process for public participation and comment and responses, and yet also needs to be balanced with the predictability of the process that Dennis mentioned. So, what Carlos mentioned is significant in that when you're dealing with a regulated facility, local zoning ordinances play a key role. It's sort of the building block. And particularly for facilities that already have permits in place, expanding or making changes, you're starting from a premise that the facility already belongs there because of zoning, because of its history, because of its permits, and yet we need to understand better moving forward what the process will look like in terms of predictability. And I think to Sean's point, also and to Carlos's point. There are already, so many opportunities throughout the existing processes for public participation. But, I think the key phrase here we've heard over and over again is meaningful participation. And what you see in the administrative order, especially, is that there has to be an outcome. There has to be, we have to get to the other side of the comments and see some proposed solutions. And I think that's where the conversation collectively needs to head.
And then
Are you
another,
looking for a comment from me, Dean?
sure.
So when I, a few years ago, I edited an updated version of a publication called The Complete Guide to Planning in New Jersey, which is published by the American Planning Association. It used to have 26 chapters. I added another 6, including a chapter on environmental justice. It now has 32 chapters and is a real door stopper. And I mention this because the planning and regulatory landscape in New Jersey is extraordinarily complex. It is extraordinarily complex. It is not something, if we were to start over, that we would create from scratch. It's very challenging. It's very challenging. And so I just mentioned this because I understand where the state is going. I completely support this effort, but I think we need to be careful not to introduce additional layers of complexity to a system that is already very, very, very complex.
And if I could add to that, while we are very supportive, I am concerned that, the department does not have a good history of timeliness for permit actions. And so as you're creating a new program like this, you only have so many people, the department. I really think the department has to look at existing programs and say, do we need to do this program, or do we need to do a program to that extent? Like somewhere, some things have to be consolidated, eliminated because of duplication or more general permits, things of that nature, to make up for all the effort and time that's going to go into this program.
Thank you to all of you. I'm going to start posing some of the questions from the chat. Okay, see nodding from Jane, so that's okay. So I'm going to start with the first question, which was posed by Ashley Werner, who says that she'd love to hear if requiring amendment of local zoning and land use was considered in the development of the legislation. Why not address the issue of overconcentration at its foundation to address the issues that Carlos was mentioning?
I can venture that. I mean, the risk of stating the obvious, the department didn't draft the legislation. We're certainly involved and consulted on our ability to ultimately implement what the legislature was after and what the sponsors wanted to accomplish. I think it's, the interplay between, the environmental justice regulations and zoning is obviously complicated. We've hit on some of those complications here. I think, if I could speculate or imagine what the legislature is thinking in that situation, it's local zoning does not at least universally take into account the things that we need to consider under the environmental justice regulations. It doesn't take into account the disproportionality of environmental and public health stressors, and that to do this effectively, they may have believed, and I think what the regulations will show is that doing this on a statewide basis with a level of consistency and predictability and reliability on data is probably a better way to get at that. And I think that the work that can be done between the department and considerations for municipalities in terms of how they might look at zoning moving forward in light of the regulations is probably, at the end of the day, going to be more efficient and more protective and get closer to the intent of what environmental justice means as indicated in legislation.
Thanks. Carlos, I saw you unmute at one point, so I wasn't sure if you were going to jump in there as well.
I don't know, but I do have one additional thought, which is that I would support personally, and I'm thinking the APA would support an amendment to the municipal land use law that would require zoning to be more responsive to these concerns. Right? Because towns act under the authority that they're given by the legislature on local land use issues. And right now, there's no check on exercising that authority from an environmental justice point of view. They can go ahead and make mistakes, and then everybody suffers the consequences. So maybe building that into the enabling legislation and making it explicit would raise the level of scrutiny at the local level, which would be beneficial.
Thank you for that, Carlos. So we have some more questions that are popping up in the chat. So I'm going to try to get to as many of those as possible. Let me see, there was one from Andrew I wanted to ask. So Andrew Shaw from Apex Management and Consulting says that since the goal of the environmental justice regulatory program is to give overburdened communities a voice, has New Jersey DEP kept track of comments received on the regulatory program from those same communities that are identified in the mapping? So in other words, is there actual sort of content from these communities that is helpful in terms of the mapping that's being created?
Sure. So I want to make sure I answer this correctly. So the question is whether we're keeping track of comments on the program. Yeah, I mean, as part of our stakeholdering, we certainly accepted written comments, and we have a record of all the comments we received from folks, including those in some of these overburdened communities, urging us to take particular positions. As part of the regulation, we've tried to be responsive to the feedback we received both from the regulated and from the advocacy community. We also conducted a number of surveys early on in our stakeholdering to allow us to hopefully better calibrate some of our outreach to make sure that we were addressing things in the way that would be most beneficial for folks to understand the process, but also getting specific feedback on some of the decisions we needed to make, particularly with regard to things like compelling public interest, which was something of very, very high concern in the advocacy community, making sure that our definition was not going to ultimately in their minds undermine the intent of the legislation. So we've taken a lot of feedback, we've considered it. We have those comments if anybody wants to see them. Certainly submit over a request and we produce all of those things. But they're there. And we also, as we go through specific permit applications, we solicit comments, and we do often receive them from individuals in overburdened communities. Those become part of our permitting record. And even before the administrative order, we were already doing things like this on projects of particular concern, ultimately looking at, at public interest to inform how we would calibrate our public process requirements. I think the AO kind of reflects what we've been doing on those projects, just, trying to provide a level of predictability and transparency to the regulated community as opposed to handling them on a case by case.
Could I do a follow-up? I'm wondering if one of the, and good morning, everybody. I'm Sue Boyle with GEI Consultants. I'm wondering if one of the things the questioner is asking is, now that you have this body of public comments from people in these specific communities, if I were to come in with a new permit application, that seems like a good reference document for me. If people in that particular community are already on record as saying X, Y, and Z, could that be a set of data that the department could provide to me right off the bat?
Gotcha.
That's really interesting.
Yeah. I mean, I think that's a good point. So thank you for helping me to hopefully better answer the question. So our Office of Environmental Justice is focused on outreach and relationship building, as well as capacity building in overburdened communities. Right, there are certain overburdened communities across the state. Newark, for instance, particularly through the Ironbound Community Corporation, are extremely well represented, organized, and able to very well articulate the concerns. What we need to be able to do is help to create more of those types of organizations across the state, so folks know who to talk to and how to address their concerns. part of what we'll be doing as we move forward with the kind of the broader approach to environmental justice we talked about way back at the beginning of this, is to build that capacity to, in its simplest term, have a database of community groups that represent overburdened communities so folks know who to talk to, how to understand their concerns, and ultimately to build our internal capacity to be able to help folks, help applicants to understand what the types of things people will be concerned about in those communities. So we absolutely aim to do that. The specific format of that we're still working on, but we will have the ability to assist in that.
So there is a very specific question in the chat. I'm going to go ahead and read it. I don't even totally understand it, but I think everybody on here will. So this is a question. This is actually Steve's question. So Steve, do you want to read it actually?
I can answer.
Okay.
If it's not, so go ahead, Steve. Sorry, go ahead.
I was just going to say, I can see, I've had this in my life where, people, one side of the street or the other, a boundary is right in the middle of the street. And people will say, well, the wind doesn't stop at the street, so why should the regulations stop there? The trucks will drive down the same road, whether they came out on the north side of the road or the south side of the road. So I'm curious how that's going to be managed, because is it, so I'd like to understand that. And it's not just for you, Sean, I guess anybody can answer that kind of stuff.
Well, I think our three-pronged test of applicability really does inform the answer to that question, Steve. I think that, what we've looked at are those three things: facility, permit, overburdened community. And if the particular facility is not located in a block group identified as overburdened community, it's not going to be subject to the regulation. Simple as that. Now, will we want to understand the concerns that folks have around there? Yes. But will you be going through the full environmental justice process? No. Answer is no. So we're not going to ignore the concerns of the community, but as far as needing to go through this and hold a public hearing and prepare the EJS, those specific requirements will not be triggered if the facility is not located in an overburdened block group as defined.
Do you think it would lead to encouragement for, the industrial user to engage in it, maybe an enhanced community outreach of their own that might, in a way, mimic a little bit, but just, you never have to produce the document, so to speak, and you just have to, work a little harder to see if you can come to, middle grounds with the people. So
I sincerely hope so, right? I mean, I think that I think the business case, the best business case for everyone is to do this type of work proactively, early, and voluntarily, whether you're going through the environmental justice process or not, right? As environmental justice becomes the way that the state does business, these concerns are going to be listened to and they're going to have to be addressed, whether it's through our process or not. Now, we are going to have a very specific process that has very specific requirements that are going to apply at very specific places. But nobody in the state under EO 23 or otherwise is going to be able to ignore legitimate concerns raised by community members, even if they're not in an overburdened community. Those community members, as they become more sophisticated, better understand the processes, I think one of the really good outcomes here is people really better understanding what their rights are and how to interact with the department and all of that. If you're not responsive, your permitting process is going to be more difficult because we're going to have to address these. But I think if businesses are engaging early, or being proactive, or doing some of this, as you're saying, Steve, kind of mimicking the process, even if you don't have to do it, I think that's probably a good idea. We're not going to require you to do all of those things, but community engagement is just going to be better for all of us. Full stop, no question.
They're going to come, people from neighboring communities that feel impacted are going to come to your public hearing anyway, so you're going to have to address it that way, aren't you?
Absolutely. I mean, these concerns are real and they're inescapable. And it's really a question of how we're going to deal with them and how we're going to be responsive. And as Dennis pointed out early, responsible corporate stewardship is to everyone's benefit.
We want to see if there's one last question from the audience before we adjourn. Okay. All right. Well, with that, what a great discussion. Thank you. I know when we initially testified on the legislation, one of our concerns was the transparency of this process and how that would impact, you know, a developer's ability to get a project through a process. And I hope that today's discussion was helpful in the start of understanding this EJ process and provided some insight into how the rules and the regulations will be implemented. I think, you know, based on today's conversation, there's already a lot of transparency built into this. And so again, thank you all for the discussion. We're having a couple of questions come into the chat, and I think if that's okay, what I'll do is I'll submit them to Sean or to whomever it's supposed to be, and then get your response. Because again, we see we're out of time, but I wanted to thank Atlantic City Electric, GEI Consultants, Highland Levin Shapiro, Montrose Environmental for their sponsorship and support of today's event. And to our speakers, a really terrific thank you for your participation. You really helped us, you know, continue to provide interesting and informative content, and we're grateful for your support. And with that, I'll submit the question from the chat to Sean on email, and then look for a response. So thank you all for joining us this morning. Enjoy the rest of your day. Take care.
Thank you, everybody.